welcome to Legally Speaking with me, Tarun Nangia. Today, we again embark on our show, which we have titled, this series is called Saturdays with Singhvis. And we're going to delve into a very important subject. This is a show where every week you see eminent jurist who has served as the Additional Solicitor General of India. We all know Dr. Abhishek Singhvi is the third-time sitting member of Parliament and former chairman of Parliamentary Committee. But most importantly, he's a very important part of a case going on in Supreme Court, which deals with the Prevention of Money Laundering Act and especially the twin conditions required for bail in PMLA cases. Also, how it is so difficult to get bail in PMLA and why it is anti-liberty is what all we will dwell into today. What is this issue all about? Dr. Singhvi will share with us in the minutest detail so that we understand why this is important for liberty and also why PMLA cases put fear in the mind of businessmen to even invest in India, not even foreign businessmen, but even local investors. Dr. Singhvi, thank you so much for joining us on Saturdays with Singhvi. Sir, if you could open the discussion today with an opening comment about the twin condition and what is the core and heart of the argument.
Thank you, Tarun. Let me, of course, start by saying that since the matter is ongoing actively and is in that sense actively sub judice, I am really here only to summarize my understanding, the submissions I made in court, summarize them more summarily and more pithily here in simple language for the audience. I'm obviously not second guessing in any manner the result. The matter is under consideration of the court, but it is more intended as educative perspective from one side of the picture. Having said that, Tarun, let me also start by a second general comment. I would personally believe that I have seen few acts which are so brazenly invasive of right to life, liberty, freedom, etc. I think this act is one of the greatest inroads, and the more you go into it, the nitty-gritty, the more the devil comes out of the detail, not God. There are many provisions. I had the privilege of arguing before the Supreme Court bench on Section 45, which is loosely called the twin conditions provision. Section 24, which talks of the reversal of the burden of proof. Section 17 and 18, which allow search of person and search of place. Section 5, dealing with attachment. And Section 8 and the rules thereunder of possession. Obviously, we don't have time to go into all that. Let me first concentrate on 45 and give you the opening comments you asked for. Tarun, we have to start with a fundamental point. The presumption of innocence is the hallmark foundation, not only of Indian law, but of common law globally. Indeed, it is in many ways part of some civil law systems also, but we're not concerned with civil law. But common law globally, from Canada to Australia, from America to India, from US, from UK to a large part of the Commonwealth, everywhere. And the old way of putting it, and I don't agree with that, I'm not saying that is necessary or required, but I'm giving you a sentiment. The old way of putting it was that let 99 guilty escape rather than convict one innocent. I'm not saying that should happen. I'm not saying I agree with that kind of a degree, but it gives you the sentiment underlying what is known as a presumption of innocence. Now, the presumption of innocence in India is even higher, is even more important because the interregnum between initiation of proceedings against you, of crime, forget PMLA, anything, and conclusion by acquittal or conviction can stretch on a reasonable basis between 7 to 10 years. People joke it is sometimes eternity. Therefore, in between, before you are convicted or acquitted, this presumption is of vital importance, and the Supreme Court in innumerable cases without end have repeated it. And this is the heart and soul of Article 21 of our Constitution. The most recent repetition of this came 2 years ago in the Arnab Goswami case, where the court said you have to be presumed to be innocent. And they said that bail is the single most important balancing factor between incarceration and possible acquittal, possible discharge, possible conviction. Keeping this in mind, what do you have in this PMLA Section 45? All your viewers have read it. It basically says that if the PP gets up and opposes, unless and until the judge can record a finding that you, Mr. Nangia, are not guilty, quote unquote, not guilty, the judge shall have no discretion to give you bail. Now remember, at that time, you, Tarun Nangia, are under trial at the highest and the worst. You are an accused. At that time, the first stage is you have no ECIR. This is another major problem which we are not discussing today. You normally get FIRs, but in the ED parlance, they call it ECIR, which is the basic document recording things about you. You don't have it. Nobody except the ED has it. Then you don't have any statements, any documents, any witnesses, any cross-examination. I am the public prosecutor. I get up in that old French joke, j'accuse, I accuse. So the PP gets up and says, I oppose, and sits down. You tell me how a accused and therefore the judge can record a finding at that stage of not guilty. Because there is no material at all. It's my word. So I can shout from the rooftops, I'm not guilty, but the judge has to record for bail, mind you. So it is actually reducing bail to vanishing point at that stage. Take the second stage, that you have gone through the initiation, you suffered in jail, and charges are filed. In ED parlance, the charges are called Prosecution Complaint. At that stage, the only difference is you have got statement of several people. Now, assume that I have got, I'm the prosecutor, I'm the ED, I've got statements of Mr. A, B, and C, which are of course furnished to the accused, Tarun Nangia. Tarun Nangia gets the statement. The statement says, I saw Nangia here, I met Nangia there, and the third statement says something like that. Now, Nangia at that stage has got no chance of cross-examination. No, he cannot produce defense evidence. So similar to the first stage, how does he prove he's not guilty? Now, the third point. Suppose you forget this case, forget PMLA. Suppose I was to pass a law in Parliament by 90% of parliamentarians in the Lok Sabha and 90% in the Rajya Sabha saying, there shall be no bail till acquittal or conviction stage in this offence. Call it any offence. You will agree with me that any court will strike it down in 2 seconds on the ground of 21. If that is your answer, then something which no draftsman is silly enough to say there shall be no bail. So they draft an equally bad provision which has the same effect of reducing bail to vanishing point. Effect is the same. The judge has to record not guilty, which is like saying there is no bail. But there you say, oh, we have sophisticated arguments why this is a valid provision. So this is de facto and de jure reducing the possibility. Nobody is saying that the judge will automatically give you bail. He can consider factors. For example, Tarun Nangia has a flight risk. Tarun Nangia can go and meet and impair witnesses. Then he will deny bail. Here the problem is not that. Here he is unable to record a finding at all unless he can record one finding and one finding alone that he is not guilty. At the stage of under trial with no documents, no material, how on earth can any judge record that? So actually it's a provision which reduces bail to vanishing point. Now, we had in the course of arguments given charts that even in offences of life, imprisonment and death, the provisions are not so draconian. In fact, I will shock you with one example, which I was shocked when I saw it. We gave a chart. Now remember, I mean, this is a little technical, it sounds also commonsensical, and that's why it's shocking. You know that PMLA is an offense of money laundering. It depends on a so-called predicate offense, which is called the basic mother offense. So 3 elements are required. Crime, let us say cheating. That cheating must be listed in the schedule of PMLA. Second element, proceeds must flow from that. And third is, those proceeds must be projected by me from being untainted to tainted to untainted. Now, I had produced a chart saying that there are about 20 offences in the schedule of PMLA. 20, which in their parent act are bailable. Can you believe that? Bailable means as of right you get bail. You don't have to even make an effort. You apply and you get bail on a surety, etc. Here, the mother offence, suppose the offence is X in the IPC, and that is scheduled in the PMLA. So for X, you are bailable. In the PMLA, you have section 45 staring in your face. You can't get bail at all.
Yes.
So it's absurd. I will continue with other elements in your second part, but this is a opening part of the Act.
See, there are 2-3 things
Some
here.
more points about it, which I'll come to. Yes.
There are attachment issues in Section 5, which, if you could explain, it would be very interesting, because that is an important element of.
Before I turn to attachment, which is mainly Section 5, let me just add a few things more on 45.
Yeah.
I've done with one part of 45, which you heard. Now, there are, as I said, offences of life imprisonment and death.
Yes.
The maximum offence punishable in the PMLA is 7 years.
Yes.
There's one exception, if it's NDPS, it is 10 years. Otherwise, all the offences in the schedule are 7 years or less.
Yes.
There you have 45, which is virtually, as I showed, no bail. In offences of life imprisonment and death, in the normal law, for example, Section 437 of the Criminal Procedure Code, you have restriction even in life and death only of a limited kind that the magistrate cannot grant, but no restriction on Sessions Court or High Court.
Yes.
So in much more serious offences, you don't have it. Here the maximum offence is 7 years. Take away the NDPS exception, that is 10 years. And yet you have a disproportionate, excessive, and therefore violative of 21 in degree situation. Number 5, Nikesh Tarachand Shah is written by one of our most brilliant now retired judges, Justice Nariman. Justice Nariman clearly struck down this provision 45, not on one but on 2 grounds. This is again forgotten. A whole web of things are woven. Of course, the court will decide. As I said, I'm only giving you my arguments. I'm not prejudging the court. But in that, there is a whole section. If I can be technical with you, I can tell you paras 41 to 48 of Nikesh, which are entirely on Article 21 violation, which is what I argued just now.
Yes.
The previous paras 35 to 40 are on Article 14.
Yes.
Nikesh came in 2018. A few months later, the law of 45 was amended by adding a few words. The argument goes that that is overruled Nikesh.
But can the amendment in the Finance Act, if I may ask you?
No, not Finance. Forget Finance Act.
Yes.
On the face of it, it cannot overrule because that amendment addresses only the Article 14 argument, 35 to 40 para numbers. It doesn't seek to address 41 to 48, which is the Article 21. There were 2 vices Justice Nariman held. You read the 2-line amendment, it says, we are putting under this whole act, earlier it said under the schedule. And that is discriminatory and arbitrary under Article 14. It doesn't address all the points which Justice Nariman addresses in para 41 to 48 or 21. That's point number 1. Point number 2, these amendments of 18 and 19 and indeed 15 have all been falsely, wrongly and illegally touted as money bills. That was done because of the certification under 110 article of the Constitution, so as to avoid scrutiny by the upper house, or at least after scrutiny have no binding effect. That is an already pending petition before a larger bench in the Supreme Court in a case called Roger Matthews. That's not the point. The point is, if that petition of Roger Matthews is allowed, namely that 2016, 18, 19, these amendments, including the amendment to PMLA, were falsely disguised and dressed up as a money bill, then the entire amendment goes.
Okay, so that will be scrapped.
So there is no amendment at all, which means 45 stands struck down as Justice Nariman struck it down.
I want to ask you for my...
I am assuming that amendment stands. Even then, 21 is not addressed.
I want to ask you for my viewers' benefit. Once a law has been held unconstitutional by the Supreme Court,
yes,
can there be any possibility of that same law being brought back?
Yes. Now, that's a good question. This is exactly what I've argued before the judges. Answer is yes in theory, provided you remove the basis underlying on the reasoning of which the judgment has been passed. So judgment is passed on pillars A and B. If you remove the basis of the pillars A and B, you can overrule the judgment. You can't pass a law saying, I hereby overrule Justice Nangia's judgment. But
you cannot
remove the basis of the judgment by changing the reasoning. All that the amendment of 2018, assuming, of course, it's a big assumption that it's a money bill which is valid. All that it has done is removed one basis, 14. It has not touched 21. And therefore, it is clearly the Nikesh Tarachand judgment which operates, which says clearly we strike down 45. So
No,
today it's a void law.
Very interestingly, there are a few fears that the business community has in this country, which are valid fears. Fear number one, there is a predicate offense in common language. Delhi police files an FIR and then the PMLA case is made out. If the businessman gets acquitted in the predicate offense, the Delhi police FIR, can the PMLA go on?
There is no way it can.
But it does go on.
Unfortunately, it does. That is one of the things this court has to decide.
Second,
I called it before the bench. I said, how can the tail wag without a dog existing? Dog is vanished, but the tail is wagging in the air on its own. It's some kind of a Trishanku in suspended animation.
point number two, which you introduced the show.
The reason, Tarun, that's an important question is because it's a tripartite 3-ingredient test. Has to be a crime. Proceeds of crime have to follow. And then there has to be a projection of those proceeds tainted as untainted.
You mean, second, I want to ask you is, if a crime has been made out, that some money obtained out of corruption is lying somewhere, but it has not been laundered to create an asset. Is it a case of money laundering?
Absolutely not. This is a crucial part. Section 3 is clear. See, suppose every crime in IPC was put in the money laundering schedule, then there will be no difference between IPC and ML.
Yes.
So that is the first offense you have to have. Then there are some offenses. Suppose I kill you out of vendetta or out of anger. It may have no proceed of crime. I just murder you. That's an IPC offense, 302.
Yes.
Now, suppose an offense, while murdering you, I rob your safe. Then comes the second element of PMLA. Cumulative and conjunctive, mind you. Cumulative, not in substitution. So crime is murder plus proceed of crime is robbing your safe. But these two by themselves will not make the offense.
You have to launder the money for the offense.
I have to project. Suppose I keep that money in my house, under my bed. Then at the most, it may be income tax offense. You do not disclose your return.
It's not a money laundering offense.
Now, I do not invest it in a house, convert it into white money by making a house, or further project it. The offense of money laundering has an essential third ingredient, namely projecting tainted as untainted.
Yes.
And therefore, the tail cannot exist without the dog. But unfortunately, the problem is these are decided by high courts. There are judgments. Justice Vibhu Bhakru has given a judgment similar to this from Delhi High Court. But point is, it needs a definitive ruling by the Supreme Court, which is what we've argued. Now, let me come to more absurdities, because you raised the vital question of foreign investors. The foreign investors, forget Indians, first of all, I'm concerned about. We are citizens of this country, you and I. Foreign citizens are equally important. Foreign investment is equally important. But why should you and I live in fear? For that, it is important to see some of the other things which you don't have time for today, but let me just touch upon them quickly. And maybe we can continue this conversation sometime later. There are some bizarre things here. There is a section 24 burden of proof. I gave a chart to the Supreme Court. I gave 11 acts in that chart. Those 11 acts include UAPA. Remember, UAPA is the most draconian. Huh? POTA, old one. TADA, old one. NDPS, Prevention of Corruption Act. Punishment is more, everything is more. The burden of proof is put partly on the accused in those also, but none like 45. None like PMLA, section 24. PMLA puts the entire burden after you are charged upon you. Whereas these acts, which are death and life, much worse, require foundational facts to be established by the prosecution before the burden shifts to Tarun Nangia. For example, all these acts say, you are accused of UAPA, but first I must prove, I am the prosecution, that Nangia was in a place which is a notified area and he had arms and that he was in possession of those arms. Then the burden will shift. This 24 shifts it straight off. Only thing is once you are charged. Now let me tell you some bizarre things on attachment, possession, because I think, I don't know how much time you have, but we have to wind down in that time. Attachment, I can understand, Tarun, because the investigation is going on. If you have converted the money into a house, you should not be able to sell the house further while the proceeding is going. So attach. Attach is a legal word for freeze. So you can't sell it. But the law in this case in section 8 and the rules provides for instant forthwith possession. of movable and immovable. Now, assume that you have laundered money and converted it into the house. I'm assuming, but you're still under trial. You are accused only. You're not a guilty person. You're not convicted. There has been no adjudication of your guilt. At that stage, I'm sorry to use the colloquial expression, why the hell should the ED be allowed to take possession having attached it? I'm leaving aside attachment. They have frozen your house, no problem. You can't sell it further. But you're living in there with your old mother, with your wife, with your children, with some aged relatives. Taking possession means instant eviction. This is while you are under trial. Before a conviction, they are taking possession of your property.
It's a very interesting point.
Now, thereafter, if there's a tenant, unless it is a registered document in a state where registration is compulsory, and most states in India don't have registration compulsory, you can choose to have a tenancy without registration compulsory. That tenant is also evicted. If it is a registered tenancy in a state where registration is compulsory, then that tenant will be allowed to stay. That's the only case where he won't be evicted. But the rent will go to the ED. Suppose I have shares. I gave the example to the court and the court laughed. I said technically after attachment means you freeze the shares. I can't sell the shares to Nangia. Nangia can't sell it to Singhvis. Singhvis can't sell it to fourth person. But having attached it, I, the ED, take Nangia's shares. Possession, remember, possession. Because you can take possession of movable as well as immovable property. Then I gave the example, I said this is not entirely a joke. The ED can use those shares to vote against me in my own company. So it becomes a shareholder because it's taken possession. What on earth is it going to serve the purpose of ED? To take possession of my house, are they going to live in it? My car, my vehicle. Do you know, have you gone across India in the normal police forces? If you go to the backyards, you will find them the graveyard of 20 cars which are rotting, which you would have to make a fantastic picture of not antiques, but derelict relics. Another very wrong thing. You have a 20-year-old house. This house you purchased 20 years, it's everybody to see it standing there. It is Tarun Nangia's house. Today, there is a crime. Let me assume you commit a crime. Let me assume there is proceed from that crime. And let me assume that from that proceed you have done nothing but you have projected it as untainted. Right? So all the ingredients are fulfilled. You are guilty of money laundering prima facie. You are not convicted, you are not acquitted. You are not guilty till then, but you are an accused. The attachment they do is not on what you have done with this money, but on your 20-year-old house.
But if that's an ancestral asset, how can it be attached?
How can you? No. See, it can't be attached at all because that is not the projection of the untainted money. Tainted money is untainted.
Yes.
Tainted as untainted will be something after the crime.
Yes.
This is 20-year-old house.
Even then it is attached, but that's illegal.
Not even then. It is always attached.
Always.
The first thing they go and attach is this.
So a house which I got from my father can also be attached.
If it's yours, I mean, joint family property stands on different, ancestral property is on the point, but suppose it's your house. The point is, your house can be 5 years old. It can be 20 years old. You may be living in it. It has no connection with your projection of untainted, tainted as untainted.
Yes.
So tainted as untainted happened after the crime.
Yes.
That cannot be attached is the argument I made before.
So basically, we also need clarity on this.
All these points, I've given you nitty-gritty reality. Forget, forget foreign investors, forget citizens, forget common sense. Take last example as your time runs out. There is a provision in the rules which says, suppose you are guilty of money laundering of 100 rupees. Now, I'm making each point separately and assuming that you can go and attach your old house, which you can't according to me. The old house, that rule says, has to be valued as on the date of acquisition.
Yes.
Not on the date when they go and attach. So 100 rupees is your offense. They will take the 10-year-old house at 20 rupees and say, look, we have attached 20, but we have to attach more properties of yours for 80 rupees. So undervaluation deliberately by the ED happens. How can you have a rule which says, take the value as on the date of acquisition? Why should it not take market value? Bhaiya, aaj aapne alleged offense किया है, आज मैं उस offense 100 रुपए के offense के लिए आपकी property attach करने आ रहा हूं, तो मैं आज की value लूंगा उस property की या तब की लूंगा जब 10 साल पहले तरुण नांगे ने खरीदी थी वो property?
That's a very valid point. Very valid.
These are all, I mean, it is draconian in the extreme. It is perverse and unreasonable. Of course, these are at the stage of my submissions, and I've comprehensively dealt with these 5 points in the arguments. It is, of course, on the Honorable Court to decide, but it is time the court gave clarity, because I think this has become now the worst instrument of fear and terror. The POTA and the TADA are no more statutes of terror. This is a statute of terror.
But as usual, Dr. Singhvi, it was a pleasure listening to you, because the kind of points that come out whenever you speak, completely unexpected, the kind of explanations you give, completely, in a sense, one is spellbound as one understands the minutiae of law. That's why Saturday Singhvi is such a pleasure to do with you. And thank you so much for your time today on this topic. But I must admit, I'll request for you some more time to do one more show and delve further into this topic coming week. But thank you so much. And thank you so much, viewers, for joining us. Thank you so much.
Again. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.